Live from Widener University School of Law this morning, a packed house for our commute with the candidates between Republican Christine O'Donnell and Democrat Chris Coons, who are entering the room as we speak. How about a nice round of applause for our candidates as they enter with us? At this time, I'd like to introduce also our panelists for today's debate. From Delaware Today magazine, Mark Nardone. Also from the News Journal, Chad Livengood. From WPVI, Channel 6 in Philadelphia, anchor Tamala Edwards. And WDEL's own Alan Ludell. A quick rundown of our rules for the morning. There will be no opening statements. In just a moment, one of our panelists will ask a question, and each candidate will have 60 seconds for an initial response. Once each has answered, we have what we call a crossfire round. That's an opportunity for the candidates to dialogue further on an issue, and the moderator will determine when we move on to a new question. We'd like to cover as much ground as we possibly can in this next 90 minutes. Also, we will have an opportunity for the candidates to present closing remarks at the end of the debate. Our first question, plus a welcoming statement from our hosts here at Widener, coming up in just a moment. Just a reminder, WDEL's Election Watch coverage brought to you by Shell Horn & Hill. Before it hits, get on top of winter with the reliability of Shell Horn & Hill. Call 658-5293. Do it today. WDEL News Time, 8:03.
All right, this is a 60-second break. Christine, we're going to flip for closing statements. Heads is Dale, Mr. O'Donnell. Okay. You go first. I'll go first and close the start. Okay. Any time signals? Yeah. What, 15 or 30? Both. I'd ask Christine as well. I'd do 30 and 50. I'd do both. 30 and 15. 30 and 15? 30 and 15. Okay.
So we have 30 seconds to respond?
2 minutes, but we'll take 1 50.
Okay.
You sure it's 2? Or some of the rules said
For closing statements?
No, well, closing statements 2, but answers to questions.
I'm not sure. 2 minutes isn't good. Follow whatever rules you got.
And welcome back to WDEL's Commute with the Candidates. We want to remind you that you can see live video of this on our website, WDEL.com. We have a live stream happening as we speak. Before we get to our first question of the debate between U.S. Senate candidates Christine O'Donnell and Chris Coons, I would like to ask the audience, this obviously is quite a monumental morning. Please, though, let's hold applause and outbursts until the end of the session here so we can cover as much ground as possible. Right now, I would like to present Mary Allen. She is Public Relations Officer of Widener University School of Law for an opening welcome remark.
Thank you, Peter, and good morning, everyone. On behalf of our Law Dean, Linda Ammons, and all the students, faculty, and staff watching and listening with her here today in the Ruby R. Vale Moot Courtroom, it is my pleasure to welcome everyone to this debate between Mr. Coons and Ms. O'Donnell. As Delaware's law school, we encourage free thinking and open exchanges of ideas that examine government, policy, and most importantly, the Constitution. And so it is with great pride that we once again partner with WDEL in the spirit of public service to provide this forum where voters can learn more about the candidates from the candidates themselves. I thank the journalists who are here today posing the questions and everyone watching on WDEL.com, on television, here in person, and those listening over their radios. Widener Law is glad you've chosen to spend part of your day with us. And to the candidates, I say good luck.
Thank you very much, Mary. Let's now move on. We are going to go to our first question, and I just want to remind the candidates 60 seconds for an initial response. I will give you hand cues at 30 seconds and 15 seconds so you can wind down the responses appropriately because, again, we want to cover as much ground and as many topics as possible. So if you can lend a little peripheral over here, I'll get you set up on that situation. Let's start the questioning now with WDEL's own Alan Ludell.
Good morning, candidates. We're at a law school. If you're a senator, you may have to pass judgment on a Supreme Court nominee. So in that spirit, I've got some legal questions. We all know by now that Chris Coons and Christine O'Donnell differ profoundly on Roe v. Wade, the decision on abortion. Let's go farther back, 65, Griswold versus Connecticut, in which the Supreme Court justices at the time found that the Constitution protected a right to privacy as the justices struck down a Connecticut ban on contraception. Is there a right to marital privacy in the Constitution? And to Ms. O'Donnell in particular, would that be an example of justices extrapolating too much, legislating from the bench?
No, I don't think that's an example of too much legislation from the bench. I don't think that the courts or Congress should legislate what a married couple does.
Ms. Liddell, Mr. Liddell, thanks for a chance to be with you this morning. It's great to be back here at Widener Law School. Of course, I would support Griswold versus Connecticut. It is a long-settled part of American constitutional law. And I think that the justices who worked hard in that particular decision to find a right to privacy and then later expounded on it and provided the foundation for Roe versus Wade, interpreted the Constitution in a modern context in a way that fulfills the early promise of the founders and that now provides a decades-old protection to a zone of marital privacy that is important to the foundation of individual liberty and the relationships that we try and uphold and protect in our constitutional democracy.
Okay, well then as a follow-up, what to you would be an example of extrapolating too much from the Constitution?
Well, you mentioned Roe versus Wade. That's one decision that I think ignores the Constitution, not just the right to protect life, but also the state's rights. As I mentioned in our other debate, overturning Roe versus Wade would not make abortion legal across the country. It would return the power back to the states. Other decisions are Kelo. I don't think that the government has a right to dictate what someone does with their private property. But also to clarify the remarks that were taken out of context in our CNN debate, under a justice who is a strict constitutionalist, both in Roberts and Rehnquist, there have been very few recent Supreme Court decisions with which I've disagreed. So I would say that I think that this court is on the right track.
Mr. Coons, anything further?
Obviously, there are some decisions I disagree with fairly strongly that the recent court has handed down. One other I'd give as an example is Ledbetter versus Goodyear. Others where I think the court was legislating from the bench, to use a phrase you used before, would be Bush v. Gore, where I think the court explicitly says this decision will have no precedent. And they were simply trying, in my view, to reach an outcome in a political case. And I think that was an inappropriate judicial intervention in the resolution of an election. Ledbetter versus Goodyear led to the very first law signed into law by the current president, which returned, I think, the real protections for equal pay for women for equal work. And it was a decision poorly decided and in a way that really deprived women from the protections of the Civil Rights Act that said that you could not be given disparate pay based on difference in gender. I'm really struck by Ms. O'Donnell's answer. You can't have Roe versus Wade without Griswold versus Connecticut, and so I think there's just some real tension in her answer today.
Would we care to elaborate now? We do have the opportunity now to do what we call the crossfire round, which is basically a chance for you two to debate further on an issue without the confines of the 60-second rule. Is there anything further you'd like to add, Ms. O'Donnell, to start?
No, simply I think that Roe versus Wade is ignoring the 10th Amendment's right for state sovereignty. I don't think that there's any tension in my remarks. And, you know, as someone who studied at Yale, perhaps they didn't teach you constitutional law at Yale Divinity School, but I think it's a very clear violation of the 10th Amendment, of the state's rights to determine what is in the best interest of their citizens.
Griswold versus Connecticut is a case that finds a right to privacy. And in your first answer, Ms. O'Donnell, you said there's nothing wrong with Griswold versus Connecticut. I would have no difference with it, no challenge. And if you understand the foundation of Roe versus Wade, you would have to also reject Griswold versus Connecticut. It is in some ways even more of a reach than Roe versus Wade to those who claim to understand and uphold a strict constitutionalist view. I oppose that. I differ. I have a different view of the Constitution, as does the vast majority of the American public and many current legal scholars. But the larger point, Ms. O'Donnell, really, is that you're not coming clean with the Delaware voters about what your real views are. As we saw in the CNN debate, you repeatedly ran away from answering clear, concise questions, whether from the moderators, from me, from students, to be clear about what your views are on a range of very important issues on which you would have to pass as a U.S. Senator. To say, for example, that it's really a question of local control, whether a school district teaches science or teaches religious doctrine. misses the basic question.
Well,
As a
let me-
repeated candidate for the United States Senate, you have made public statements on everything from choice, individual liberty, evolution, and others that I do think our voters deserve to hear a clear answer from you.
Great, let me clarify your remarks. Mr. Ludell's question was about marriage, not necessarily about the so-called right to privacy. Now, you say that you have a different view of the Constitution. I would agree with you that you do have a different Constitution, because in the CNN debate, you stated that there were 3 constitutions. And you don't need to go to any kind of Ivy League school to know that we have but one Constitution. And in all of my remarks, it is said that that one Constitution is the Constitution that I will defend. I've made my positions very clear. Everybody knows where I stand on issues, but even where I stand on certain social issues, I will defend our constitutional right to disagree, and I have made that very clear. Our Constitution is not in opposition to my personal beliefs, and it's not in opposition to someone who might have a different position on these social issues than I do. Our Constitution protects our freedom to disagree.
That's right. And I'm grateful for this chance to continue to disagree. I just hope you'll come clean with the folks of this state and the listeners to this debate
I have
about
come
what
clean
your
on
real
every
views
position.
are. Well, then answer the question. Do you believe in evolution?
What I think about the theory of evolution is irrelevant, because I will defend...
Again,
a
you're
local-
dodging the simple question.
What
It's a
is my-
settled scientific
Now listen,
fact.
let me ask you, what is the relevance on that, other than campaigning on Sunday mornings, which you tend to do, going to the churches, and, do you disagree with the positions that those several churches that you've been attending? I mean,
I
are you
believe
gonna tell
that
them you're
I
gonna
believe
show up just
churches
to get
have
their
the
vote?
absolute right to believe whatever religious doctrine they wish
And do
to.
local
But you
schools have the
cannot
right to
impose
teach
the
that?
they do not. Public
Local
schools
do not have the
They
right
do
to
not.
teach what they feel. Well, there you go.
Religious
You want
doctrine
a
does
senator
not
who's gonna
belong in our
impose
public
his
schools.
beliefs? Talk about imposing your beliefs on the local schools.
Right.
I'm saying that if a local community wants to teach the theory of evolution, it's up to the school board to decide. But when I made those remarks, it was because the school board wanted to also teach the theory of intelligent design, and the government said that they could not. You have
That's right.
just stated that you will impose your will over the local school district, and that is a blatant violation of our Constitution.
And to be clear, Ms. O'Donnell,
who's going to do that?
to be clear, Ms. O'Donnell, I believe that creationism is religious doctrine and that
How about the
evolution is
theory of
broadly
intelligent
accepted.
design?
Creationism, which you'd
Theory
like
of
to call the
intelligent
theory of
design.
intelligent design, is religious
No, two
doctrine.
different things.
Evolution is widely accepted, well-defended scientific fact. And our schools should be teaching science. If we want to instruct our children in religious doctrine or religious practice, as my wife and I choose to, that's wonderful. That's what our churches are for. And that's what private or parochial schools are for. But our public schools should be teaching broadly accepted scientific fact, not religious doctrine.
Well, you've just proved how little you know, not just about constitutional law, but about the theory of evolution. Because the theory of evolution is not a fact, it is indeed a theory, but I'm saying that that theory, if local school districts want to give that theory equal credence to intelligent design, it is their right. You are saying it is not their right. And
That's right.
That is what has gotten our country into this position, is the overreaching arm of the federal government getting into the business of the local communities. The Supreme Court has always said it is up to the local communities to decide their standards. The reason we're in the mess we're in is because our so-called leaders in Washington no longer view